So now that we understand the economics of the problem and a possible economic solution, we have Professor Charles Rounds, who is a law professor, to tell us about whether or not that legal structure would be in place and some of the legal reasons for reforming the system right now. He is a tenured professor at Suffolk University Law School and a member of the Massachusetts Bar. He's also a resident scholar at the Beacon Hill Institute, an academic fellow of the American College of Trust and Estate Council, and a member of the advisory committee to the Cato Institute Project on Social Security Choice. He's authored several articles on Supreme Court precedents of how they're affecting the current system, the regulatory framework necessary for reform, and theories of property rights. He's a graduate of Columbia University and holds a JD from Suffolk University. So please join me in welcoming Professor Charles Rounds. Thank
you. Ladies and gentlemen, let me look at this, or let's us look at this from the legal perspective for a moment. I don't necessarily disagree with anything that has been said so far, but I might perhaps say it a little differently. One of the most enduring myths of Social Security is that there is a right, I'm talking about the current system now, that there is a right to Social Security benefits. Many workers assume that if they pay taxes into the system, they have some sort of legal right to benefits out of the system. This is not surprising. Much of the language surrounding the Social Security program is designed to convey that impression, and that has been since the New Deal. For example, payroll taxes are called insurance contributions. Social Security monies are placed in a so-called trust fund. In reality, however, all those terms are misleading to the point of dishonesty. The U.S. Supreme Court has ruled that payroll taxes are not contributions as we ordinarily understand it, but are taxes like any other tax. Paying Social Security tax does not give rise to any contractual right to Social Security benefits. In the Social Security Trust Fund, there is no property. No property is held in trust for any workers or collection of workers. What's going on is essentially, and this has been confirmed twice by the U.S. Supreme Court, is that we have Social Security is an umbrella term for two legally unrelated regimes, a taxation regime and a welfare regime. The taxes, the FICA taxes that we pay in are not segregated in a trust. They are commingled with the general assets of the U.S. government and are available for spending on anything from aircraft carriers to the president's cigars. There's a separate program, a welfare program, pure and simple, and as a general rule, we have no contractual rights to welfare payments. And this has been confirmed by two U.S. Supreme Court cases. The first is, or the second actually, is Fleming v. Nestor. It was decided in 1960. The Supreme Court ruled, just as I said, that it's an umbrella scheme for two unrelated regimes. This was particularly interesting because Mr. Nestor had accrued a fair amount of benefits under the Social Security system. And then it turned out that Congress enacted some legislation saying that anybody who had been a communist would effectively lose benefit rights. He had been a communist in the 30s, and he was stripped of his benefits. And of course he got very upset. He said, well, gee, you know, I've accrued all these rights over the years. You can't retroactively take away my property rights. And the U.S. Supreme Court said, tough. You have no standing. Get out of court. There are no property rights here. There's no Fifth Amendment takings issue or whatever. You have no constitutional right to your accrued Social Security benefits. These are all euphemisms, you know, accounts, rights, promises to seniors, social insurance. These are all euphemisms for welfare. Fleming stood on the shoulders of a Supreme Court case that came down in 1937, Helverine v. Davis. And in that, the constitutionality of Social Security was at issue. Had it been an government-sponsored insurance scheme, then arguably it would have been unconstitutional. So its constitutionality was upheld on the basis that it was a welfare program and came within the welfare clause of the U.S. Constitution. So when people debate whether partial privatization is a good idea, sometimes the debate is misframed, in my opinion. It isn't government guarantee versus market risk. It's political risk versus market risk. And if the public were to understand that difference, they might be more receptive to reforms that are being proposed this evening. Now to my area of expertise. Let's talk about this trust fund. If I know anything, I know about trusts. I've spent my life studying trusts, working with trusts, litigating involving trusts. If individuals have no direct property right in Social Security, is there perhaps an indirect one through the Social Security Trust Fund? That comes out of the legislation. Now, a trust is a fiduciary relationship with respect to property. That's the technical meaning. The trustee, a real trustee, takes title to property in the trust and holds it for the benefit of beneficiaries. And the assets in a trust are segregated from the assets of the trustee and insulated from the creditors of the trustee and insulated from any effort on the part of the trustee to alienate the underlying assets other than for purposes of looking after the beneficiaries. The beneficiary's interest in a trust is said to be an equitable or beneficial interest. Bottom line, there is no Social Security Trust Fund, none whatsoever. The term appears in the legislation, and then sort of perniciously, disingenuously, shamelessly, Congress then strips this thing of any attributes of a common law trust. So there is no trust fund. The trust fund, Social Security Trust Fund, is really a euphemism, again, for welfare. Now, what about those bonds in the fictitious Social Security Trust Fund? Are they real or not? Some of you have heard that there are out there Social Security bonds that are funding the system. And again, I would question whether we can call welfare two unrelated regimes a system. But this somewhat esoteric legal issue is important because the popular misconception that there is some kind of full faith and credit obligation on the part of future Congresses to honor these bonds, aids and abets the disinformation campaign of the AARP, the labor unions and others, that the current system is a retirement program funded with segregated entrusted assets, the integrity of which is guaranteed and backed by the U.S. government. As I said, Social Security is just another federal welfare program that is funded out of general revenues. It may be dismantled at any time at the whim of Congress and everybody. We can be compelled, and this was discussed at the level of the U.S. Supreme Court, we can be compelled to continue to pay FICA payments in, and Congress can eliminate the welfare component. We could just continue to pay the FICA payments into the general revenues. This misframed debate about whether there is a Social Security cash flow crisis in 218 or 242 or whenever, and I defer to the economists as to what these dates are, it's been said it turns on whether those bonds have any economic or intrinsic value. The argument that Social Security will not cause a serious drain on general revenues until 2042 presupposes that the bonds in the fictitious trust fund memorializing the spent surplus somehow have value either for the U.S. or for workers and their families. They do not, everybody. It should be noted that each side of the cash flow crisis debate is presupposing, or not everybody, but many, is presupposing that Social Security is a self-contained retirement program, which legally it is not. But back to those bonds. A bond is just a contract, all right, an agreement between two parties. Agreement to pay a certain amount plus perhaps interest. It creates a legally enforceable obligation. But generally, everybody, one cannot contract with oneself. One cannot create a legally binding contract with oneself. One cannot issue a bond to oneself. And that's essentially what those Social Security bonds are. It's the U.S. government musing with itself about what it might do in the future. It does not bind future Congresses to do anything with respect to the system. In order for those bonds to have value, they have to be issued to someone else, and that does no one any good. If the system possessed a German bond, well, then that might have economic value because it might be enforceable against the German government, for example. So one has to be very careful as one considers and debates the issue that one gets the terminology correct. And to suggest that these bonds are real bonds only stands in the way of a clear understanding of what is going on. The legislation itself, and it's so disingenuous, says those bonds may not be issued, which in effect means they are not bonds. Now I'd like to touch on some dangers that lurk around the proposal to reform Social Security. And I'm a proponent of Social Security reform, and I certainly have argued for privatized accounts. We've got to be careful that the reform movement doesn't get hijacked. Let me explain what I mean. Right now, FICA payments are paid into the U.S. government, commingled with the general assets of the U.S. government, and Congress expends it as it wishes. Some people have proposed, well, okay, let's take these FICA payments and let's Congress says this, let's declare the United States government as the trustee of these FICA payments, and let's have the U.S. government invest in the equity markets. I think the current status quo would be infinitely better. It would be better to have the welfare system with all its faults than have the U.S. government take large chunks of the equity markets in the United States, large pieces of U.S. companies, have proxy power and whatever. And no amount of legislation to build in safeguards will bind future Congresses. There's just too much opportunity for political mischief, what we call in the trade social investing. Politicians would get into the act, and eventually there would be voting of proxies, and pressure would be put on companies and all the rest. Well, all right, then why don't we set up real trusts, make the U.S. government the trustee, and the U.S. government can then invest these assets as a normal trustee would do for the benefit of the workers, a real segregated trust fund, segregated from the general assets of the U.S. government. I would caution anybody that proposes even that, and that's, I think, maybe where we may disagree a little bit. Maybe we can talk about the reasons why we disagree. I am very, very concerned about the U.S. government getting into the investment business in any way, no matter how indexed, no matter how universal it is, because one Congress cannot bind a future Congress, and there's all kinds of opportunity for political mischief. And we go back to the fundamentals of trust law. Even assuming a real trust is established segregated from the general assets of the U.S. government for the benefit of the workers, there is the problem of enforceability. As a general rule, one can't enforce a private system is going to have a very difficult time enforcing these arrangements against the U.S. government. There's an ancient principle that one cannot enforce a use or trust against the crown. And so I worry, even if all kinds of safeguards are put in place, I worry about having the U.S. government get into the investment business in any way, no matter how indexed or structured or universal it may be. And the other principle, besides one cannot enforce a use or trust against the crown, is that one Congress cannot bind a future Congress. You would need a constitutional amendment to do that. And so any safeguards that were put in to prevent social investing or political mischief with the segregated funds could easily be undone by Congress. So there aren't a lot of legal protections. About the only, if you're concerned about legal protections, about the only protections that are available are fully segregated, privatized trusteed accounts, where the workers can go into court and compel the financial service providers, whether it be Fidelity or whatever, to carry out the terms of the instrument or the arrangement. Still, there are problems, because even in a privatized system that's been proposed, of the type that's been proposed by Cato and whatever, it still would be regulated by somebody, SEC, Department of Labor, or somebody. So there's always that opportunity to make mischief when it comes to regulation. And there's always still the power to tax. You know, there'll be very few checks on that, so you won't be able to resolve that particular issue. But there are Fifth Amendment protections if you keep the United States out of the investment business and make sure that private entities are doing the investment work. At least they're accountable in the courts, state courts and the federal courts. So I guess if I have any disagreement at all with what I've heard so far, I guess it relates to that narrow area.